All right, let's jump right into this explainer. We're looking at literally the biggest shakeup to UK venue security regulation in decades. We're talking about the Terrorism Protection of Premises Act, 2025, which you probably know better as Martyn's Law. For years, keeping public spaces secure in the UK was basically just voluntary. But yeah, that era, it's officially over. So today, we're breaking down exactly what this landmark legislation actually means, who's affected, and what you've got to do to get ready.
Here is our roadmap for today. We'll quickly cover the catalyst for change, introduce Martyn's Law itself, break down the new two-tier system, walk through the 4 core protection procedures, and finally, look at the cost and the countdown.
Okay, part 1, the catalyst for change.
We really have to start by looking at the sobering reality that sparked this whole thing. This law didn't just appear out of nowhere, right? It came from unimaginable tragedy and a really hard look at our systemic vulnerabilities. Just look at the numbers. Since March 2017, the UK has sadly seen 15 terrorist attacks. And as the Home Office points out, these attacks often targeted everyday public venues. The most devastating, of course, was the Manchester Arena bombing back in May 2017, which tragically claimed 22 lives. It was the devastating loss of Martyn Hett in that attack, and the absolutely tireless campaigning by his mother, Figan Murray, that ultimately gave this legislation both its name and its momentum.
And this quote right here hits the nail on the head regarding the core problem. Various inquiries all found the exact same flaw. Until now, installing security at public spots was entirely up to the venue. The Intelligence and Security Committee and the Manchester Arena inquiry essentially said, look, without a legal duty, security just gets pushed to the bottom of the to-do list behind other mandatory stuff. Some venues were doing a great job, sure, but overall, the results were dangerously inconsistent. Which brings us to this concept, information asymmetry. Sounds a bit technical, but in plain English, it means the government and intelligence agencies know exactly what the specific evolving terrorist threats are. But the individual businesses on the ground, your local pubs, theaters, community halls, they are mostly in the dark about their actual risk. That gap leaves the public vulnerable. So the government is stepping in to level the playing field and mandate real security outcomes.
Moving on to part 2, introducing Martyn's Law. To close that dangerous information gap, the government is turning venue security from a nice-to-have into a strict legal must-do. Just look at the timeline. It's been a massive multi-year journey, from that devastating catalyst in 2017 through huge public consultations starting in 2021 where thousands weighed in, all the way to the act getting royal assent in April 2025. What does that mean for you right now? Well, the clock is officially ticking. Venues have a super tight 2-year window to get their house in order before enforcement kicks off in spring 2027. And guys, the scale of this is just massive. The Home Office estimates there are over 928,000 public locations in the UK. Out of those, a whopping 178,900 sites are going to fall directly under this new law. We are talking shops, restaurants, pubs, hotels, sports grounds, museums, even schools. Basically, if you run a place where the public gathers, there's a really high chance you're one of those 178,900. All right, let's get into the mechanics. Part 3, the two-tier system. The government knew a one-size-fits-all rule simply wouldn't work. So they split the obligations based on a simple metric, capacity. How many people can your place hold? And, heads up, that capacity includes your staff and contractors, not just the public. If you're a standard duty venue, meaning 200 to 799 people, you've got to notify the regulator, which is the Security Industry Authority, or SIA, and set up basic public protection procedures. It's designed to be fairly low cost, mostly taking up your time. But if your venue holds 800 people or more, boom, you hit the enhanced duty. This is the big leagues. You have to run formal terrorism risk assessments, install actual physical protective measures, and here's the kicker, you have to appoint a specific senior person who takes personal accountability for compliance. Let's look at exactly what you need to do. Part 4, 4 core protection procedures. Whether you're standard or enhanced, the new Section 27 statutory guidance tells you exactly what operational triggers you need ready to go. Having some dusty generic emergency plan sitting in a drawer, yeah, that's not going to cut it anymore. You need clear, actionable, rehearsed plans for 4 interdependent things: evacuation, evacuation, lockdown, and communication. And the guidance makes one thing crystal clear. Communication is the absolute linchpin here. Without instant, clear comms, you literally can't trigger the other 3 in time to save lives. Now, evacuation is pretty self-explanatory, but in-evacuation is probably a new word for a lot of mid-sized venues. Imagine a busy high street and suddenly there's a threat outside. Pushing all your customers out the front doors into the street, that could be an absolute disaster. Evacuation is having a solid plan to quickly and safely move everyone to a secure area inside your building, totally away from that exterior threat. And please pay attention to this because it's a vital, life-saving detail from the guidance. Do not use your standard fire alarms during a terror incident. Why? Well, think about it. We are all deeply conditioned to hear a fire alarm, walk outside, and stand around in an open assembly point. If there's a terror threat, corralling your staff and customers into a predictable open crowd outside is exactly what you shouldn't do. It could put them directly in harm's way. Finally, let's talk about the bottom line. Part 5, the cost and countdown. Look, changing the security posture of an entire country doesn't come cheap. And as that deadline rushes toward us, the financial reality is hitting hard. The Home Office Impact Assessment estimates an immense financial weight, a massive net cost to businesses of over £1.78 billion over 10 years. Naturally, most of that falls on the enhanced tier venues. They've got to buy physical infrastructure like CCTV and secure barriers, hire extra security personnel, not to mention the sheer mountains of admin hours required across all 178,000 affected sites. Now, if you're thinking, well, maybe I'll just skip this and take the hit to save some cash, think again. The cost of noncompliance is way, way worse. If an enhanced duty venue ignores Martyn's Law, they could be slapped with mind-boggling fines up to £18 million. The SIA isn't messing around. They are mandated to enforce this. So there is a very, very strong financial reason to get your security sorted out. Because of these new rules and those terrifying penalties, the whole security industry is basically getting flipped on its head. We're about to see a massive, unprecedented scramble for qualified SIA-licensed professionals who actually understand crisis management and counterterrorism. To keep up, the SIA is currently doing its biggest qualification overhaul in years. They're making sure new, much tougher training standards are ready to go live right when enforcement starts in spring 2027. So the implementation clock is ticking loudly, and we're already burning through that 2-year transition window. The absolute best time to figure out your capacity, overhaul your procedures, and upgrade those comm systems is right now. Are you really going to wait to an inspection to find out you're non-compliant? Or are you going to step up and make sure everyone goes home safe at the end of the night? With the whole country about to scramble for the exact same security resources, if you don't start preparing today, will you even be able to find the help you need tomorrow?